Okay, so we already finished discussing justifying, exempting, and mitigating circumstance in our previous video. So we will finish all the circumstances affecting criminal liability. Let's start with aggravating circumstance. So when we say aggravating circumstance, the circumstance or the action, no, either changes the nature of the offense to make it more serious. So this is what we call qualifying circumstance, no? So qualifying circumstance is another form of aggravating circumstance. Like for example, robbery, from theft to robbery, homicide to murder. For example, if the act of taking a personal property, no, from one person to another, the act of taking a personal property from one person to another is considered theft. Okay, but if the act of taking is with force and violence, so the circumstance of force and violence will make the crime robbery. So instead of, if the taking is with force upon things or force against person, then the crime changes its nature and the penalty became higher, no? So from theft to robbery. So in homicide to murder, if there is use of superior strength, no, use of superior strength, or there is treachery involved, no, if there's treachery involved, instead of homicide, it will become murder. Technically, so it means to say that the penalty will also increase. So that is aggravating circumstance, more specifically qualifying circumstance. So it changes the nature of the crime. So example, from theft to robbery, homicide to murder. Aggravating circumstance can also be circumstances that makes your penalty that will make the penalty imposed in its maximum period. Okay, so for example, in murder, no, so or for example in rape, if the penalty of rape, diba, as I discussed earlier, if there is the absence of mitigating and aggravating circumstance, the penalty for rape will be in its medium period. So, example, I'm not sure of the 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 correct period for rape, because that's beyond our topic. So if for example the penalty for rape, imprisonment of rape is from 8 to 13 years. Okay, so the medium period for that is 8 to 9 years. The minimum period, I mean, is 8 to 9 years. Medium is 10 to 11 years. Then the maximum period is 12 to 13 years. So that's how we're going to classify the minimum to maximum period, because the penalty, no, ranges, di ba? If you listen to some legal dramas, you can observe that the penalty is from 8 to 10 years or something like that. The penalty is not specific that you will be in prison for only 8 years. No, there is a range, no? So that's where the indeterminate sentence law will come in determinate sentence law, which is another topic, and it's quite hard, no? It's for judges. Okay, so for example, the minimum period of rape is 8 to 9 years, the medium is 10 to 11, and 12 to 13. So in the absence of any aggravating circumstance and mitigating circumstance, the judge will penalize the rapist for an imprisonment of 10 to 11 years. So if there is an aggravating circumstance, the penalty to be imposed will be in its maximum period, which is 12 to 13 years. So that is aggravating circumstance. There are 4 kinds of aggravating circumstance. The first one are the generic, no, meaning it can be, the circumstance can be used in all other crimes in the revised penal code. Like um, for example is ba, 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 ba. If you commit a crime with aid of person under 15 by motor vehicle, okay, that is one of the aggravating circumstance. So for example, if you rob someone, no, if there's robbery with the aid of person under 15 years old through the use of motor vehicle, then the penalty will be imposed in maximum period. For robbery, it will be imposed in its maximum period. If you rape somebody with the use of with the aid of person of 15 years old, under 15 years old by motor vehicle, um, then that will still be considered as a aggravating circumstance. So what are other circumstances that are considered generic? Abuse of confidence and obvious ungratefulness. So if you committed rape, through abuse of confidence, then the abuse of confidence will be used as aggravating circumstance to impose the maximum period of rape. There are 21 aggravating circumstances under Article 14, but these are not all but this is not an exclusive list of aggravating circumstances. Therefore, there are many more. There are more than 21 aggravating circumstances, but the revised penal code only enumerated 21 under Article 14. Okay. So generic, meaning it can be used in all crimes. Specific, there are own specific aggravating circumstance are those aggravating circumstance that will be used in specific crime. Let's say, for example, let's say, for example, example here is treachery. So you cannot treachery is ano ba, what's the Tagalog term for treachery? Pagtataksil or pagdadarambong, is that a correct term? Panlilinlang, okay? Panlilinlang or pandaraya. You cannot use panlilinlang and pandaraya if the crime is committed against person, okay? I know, against honor, crimes against honor, so such as acts of lasciviousness, it cannot be used, because wala namang panglilinlang sa acts of lasciviousness. Panglilinlang is, or treachery is used more on crimes against persons, such as murder, such as physical injuries, so things like that. Okay, so as specific, those are only applicable to particular crimes. Qualifying, the next kind of aggravating circumstance is qualifying. This is what I explained earlier, na it changes the nature of the crime from robbery to from theft to robbery, or from homicide to murder. Okay, so example is use of superior strength in homicide. So instead of homicide, it will become murder. Okay, inherent, so meaning that that circumstance is part of the commission of the crime, or it's part of the crime itself, and it will not be considered in the imposition of the penalty. Okay, so for example, use of fire. So in case of arson, so obviously when you in cases of arson, it is through the use of fire. So even if the crime is, you cannot make the use of fire as an aggravating circumstance in order to impose the maximum penalty for arson. Okay, then special, these are arise from special conditions that will increase the penalty of the offense and cannot be, this is important, cannot be offset by a mitigating circumstance. So example is quasi-recidivism, we already discussed that. Complex crimes, that is under our module 8, which we left out, no? Error in persone, complex crime, error in person, taking advantage of public position and membership. So those are special aggravating circumstance that cannot be offset by mitigating circumstance, meaning if there is any of the four special aggravating circumstance, then automatically, even with the existence of the mitigating circumstance, the penalty will be imposed in its maximum period. Okay, there are again 21 aggravating circumstances mentioned in Article 14, and we cannot go through it one by one. So please familiarize with with the 21 aggravating circumstances. Those are, most of them are self-explanatory. Okay, you just need to look for the you just need to use your dictionary if you cannot understand the terms, no, such as ignominy, so shaming, shameful acts, no, or humiliation. So you committed a crime and humiliated someone, like for example rape. You rape someone and then you humiliated her further by laughing at her, by allowing other people to witness the act of rape. So that's ignominy. Okay. Then let's proceed to three types of alternative circumstance. Alternative circumstance can be, depending on the situation, no, depending on the facts of the case, can be considered either as aggravating or mitigating circumstance. That is what we call alternating circumstance. Depende. Okay. There are three alternative circumstance, meaning there are three alternative circumstance. One is relationship. Number two, intoxication. Refer to alcohol intoxication. Degree of education or instruction, or your degree of education, highest educational attainment. These three circumstances can be either aggravating or can be a mitigating circumstance. Okay. So for example, relationship, no, relationship in cases of in case of rape. Okay, in case of rape, your relationship to the rape victim is an aggravating circumstance, no. You rape your own child, that is an aggravating circumstance. It can also be a mitigating circumstance in case of robbery, no. Okay, if you rob or if you stole something from your relative, then it can be considered as, there is even a in theft, no, if you stole something from your relative, then it is considered a mitigating circumstance. So in short, these three circumstances has a different application from different situation, in different situation. So intoxication, we just need to remember in intoxication that There are two requirements for it not to be considered mitigating circumstance. First, habituality. It should not be habitual, so meaning you should not be an alcoholic, no. If you are alcoholic, then intoxication can be considered as an aggravating circumstance. And then the intoxication was not used to was not intentional to embolden the offender to commit crime, meaning it was in the intention of for example, the rapist drinks alcohol to be intoxicated in order to lower his inhibition and to commit the crime of rape, then that is aggravating circumstance. Okay, but for example, he was intoxicated because he went to a party and there was no intention at first for him to rape someone, but because he was heavily intoxicated, then during a party, then he committed the crime of rape. The intoxication can be considered as mitigating circumstance. Okay. We have absolutory circumstances. These are additional notes. This is not part of your modules, no. Absolutory are these are defenses which has the same effect as the exempting circumstance, but they are not among those enumerated in Article 12. They are found in certain articles of the Revised Penal Code or are developed by jurisprudence. Examples are those non-liability of attempted felony due to voluntary desistance, okay, death under physical or injuries death or physical injuries under exceptional circumstances. Example here is that when the husband caught his wife at the act of sexual intercourse with another man, and if he kills the paramour or his own wife, then he is exempted from criminal liability. Okay, that is absolutory causes. Then we also have extenuating circumstances, those which have the same effect as mitigating circumstances but are not among those enumerated in Article 13 but are provided in certain articles of the Revised Penal Code and apply only to certain felonies. They are called special mitigating circumstance. Example, abandonment in adultery cases. So for example, if the husband was abandoned by if the wife was abandoned by his husband and she commits the crime of adultery, then the abandonment of the husband is considered as mitigating circumstance. Okay, so that would be all. So we covered all the topics for our pre-term 1 exam. Good luck on your pre-term exam tomorrow.